The next 30 seconds would decide whether a rookie Congresswoman could force a federal courtroom to obey its own rules, or whether a lifetime of unchallenged authority would smother another civil rights case before it drew breath. The hallway outside buzzed like a beehive of whispers and camera shutters. Inside, the air felt charged, metallic, a storm waiting for a single lightning strike. When Jasmine Crockett pushed open the heavy oak doors and stepped onto the worn runner, every head pivoted. The bench was already occupied. Judge Andrew H. Stones, perched high, framed by a flag, a seal, and the weight of 2 decades spent treating his gavel like a scepter. No one in the gallery could agree on when the smirk started. Some swore it appeared the moment Crockett crossed the bar. Others said it curled as the clerk announced her name. But everyone clocked it. A small, complacent crescent with the confidence of someone convinced tradition will always back him up. Crockett didn't slow. Burgundy blazer, legal pad at her side, she moved with the practiced economy of a trial lawyer who had learned to save her breath for impact. She placed her folder on the plaintiff's table, eyed the microphones, tested the audio with a single word. Ready. "Congresswoman Crockett," the judge said, mispronouncing it the way a person misbuttons a shirt, carelessly, as if the mistake were a feature. "I understand you have concerns about judicial proceedings. How refreshing. Please, enlighten the court." 2 rows back, a reporter underlined the word refreshing 3 times. Crockett didn't blink. "Your Honor, it's Crockett, and the concerns are about the constitutional rights of 50,000 Texans. I'm prepared to present evidence." A shuffle of paper from the defense table, a trio in conservative suits, cufflinks glinting, with the relaxed posture of a team that has never seen a gate they couldn't get waved through. Stones leaned back, his robes folded like a curtain preparing to drop on a performance he'd already reviewed. "Proceed," he said, drawing out the word like a dare. Crockett began clean. No throat clearing, no soaring overture. "This case concerns a coordinated pattern of polling place closures, resource depletion, and procedural hurdles that disproportionately burden Black and Latino voters. We will show, through documentary records, statistical analysis, and first-hand testimony, that the right to vote was deliberately constrained. We will also show that the defendants knew, or should have known, the foreseeable impact of those decisions." "Objection," defense counsel interrupted before her second sentence landed. "Speculation as to intent." "Sustained," Stones said, almost pleasantly. "Congresswoman, facts, not speculation?" Crockett's pen landed on her pad with a soft click. Hook set, she adjusted. "Then let's start with the facts. Exhibit 3A, closure notices for 8 precincts in majority Black neighborhoods, issued within 72 hours of Election Day. Each notice directs voters to an alternative location already at capacity." "Objection," defense said, already half standing. "Relevance and foundation," sustained. "Lay your foundation, Congresswoman Crockett." She didn't look at him for the mispronunciation this time. Foundation will be established through records custodians and the state's own logistics memos, which the defense produced in discovery. For relevance, these closures correlate with measurable delays that resulted in voters leaving lines after waiting over 2 hours. The correlation is supported by time-stamped line-length reports and sworn declarations. Defense rose again. Objection. Hearsay as to declarations. Sustained. A murmur dusted the back rows. Crockett's expression didn't change. Her posture did. She straightened a fraction, then slid Exhibit 3A back under the folder as if returning a chess piece to its square. "Then we'll begin with statistical impact. Exhibit 4C, aggregated wait time data by precinct, verified against the county's own line monitoring feed. The data show a median wait of 12 minutes in majority white precincts and 87 minutes in majority Black precincts during the same hours." Defense didn't even lift his hands this time. He just said, "Objection," like a password. "Sustained," Stones said smoothly. "Speculative causation. And Congresswoman, do refrain from political rhetoric. We are a court of law." Judge Andrew H. Stones never returned to the bench. His medical leave announcement, thinly veiled as concern for his health, was recognized instantly as the retreat of a man who understood his career was already over. But the machinery of accountability, once awakened, did not stop with his absence. Within a week, the Judicial Conduct and Disability Committee confirmed that they were reopening their investigation into Stones based on the new evidence Congresswoman Jasmine Crockett had laid out. 3 of the very cases she cited filed motions to reopen, arguing that judicial misconduct had tainted their outcomes. The Justice Department, cautious but watchful, quietly began reviewing Stones' civil rights rulings from the past decade. Legal watchdog groups compiled dossiers of his decisions, circulating them to law schools, civil rights organizations, and investigative journalists. For every case Crockett had mentioned in court, 2 more began surfacing. The portrait that emerged was not just of one bad day or a handful of missteps. It was of a 20-year career built on a pattern of disdain for civil rights plaintiffs. Crockett, meanwhile, became a lightning rod. Her congressional office overflowed with letters, emails, and phone calls. Civil rights attorneys from around the country reached out to share stories of their own battles with hostile judges. Law professors invited her to lecture about judicial accountability. Advocacy groups hailed her as a hero for doing what many had wanted to do but never dared: challenge a federal judge in his own courtroom with nothing but the truth. On television, the commentary spanned the spectrum. CNN's Jeffrey Toobin called her performance the most effective piece of courtroom advocacy I've seen in 3 decades. On Fox News, conservative legal contributor Judge Andrew Napolitano, despite his ideological leanings, admitted her research was impeccable, her presentation flawless, her arguments unassailable. This is how the system is supposed to work. Even critics on the right found it difficult to dismiss her when the record was undeniable. The case itself, now under Judge Maria Rodriguez, shifted dramatically. Evidence that Stones had refused to admit was entered without resistance. The video footage once mocked as amateur became central to proving constitutional violations. What had begun as a lawsuit dismissed in advance by a smirking judge turned into a landmark case, resulting in a multi-million-dollar settlement and court-ordered election reforms. For Stones, the fall was swift and brutal. 6 months after that fateful day, he submitted his retirement papers, citing a desire to spend more time with family. No one was fooled. His legacy was gone, his authority shattered, his career a cautionary tale. His replacement, confirmed with bipartisan support, was a civil rights attorney who had spent her career fighting the very kinds of bias Stones had represented. But the collapse of his career was only part of the story. The broader legal system was forced to reckon with the implications of what had happened. The Judicial Conference announced mandatory bias training for all federal judges. The American Bar Association revised its guidelines for reporting judicial misconduct. Law schools began teaching Crockett's strategy as a model of effective advocacy against institutional bias. Across the country, attorneys inspired by her example started documenting patterns in their own jurisdictions, challenging judges who had long operated unchecked. The methodology became known as the Crockett Protocol, a systematic approach to exposing bias through research, precedent, and unflinching presentation in open court. For the federal judiciary, the message was clear: unchecked authority was no longer untouchable. For Crockett, the victory was not about headlines or viral clips, but about the precedent it set, that even the most powerful robe in the courtroom could be held accountable. Judge Stones' career ended not with dignity, but with silence. Crockett's star, by contrast, rose higher than anyone expected. And the balance of power in America's courtrooms shifted, however slightly, toward the people those courtrooms were meant to serve. The day Judge Andrew H. Stones stepped off the bench for the last time, a ripple spread across the entire legal system. What had started as a tense courtroom standoff became a catalyst for reforms that would echo for years. Congresswoman Jasmine Crockett's performance was no longer just a viral moment. It was a landmark in American jurisprudence, studied, debated, and remembered as the turning point when accountability finally pierced the armor of judicial immunity. In the months that followed, the Crockett Protocol became a fixture in law schools. Professors taught it not as theater, but as strategy: meticulous preparation, relentless documentation, and fearless presentation. Students dissected how she structured her argument, how she wielded appellate reversals like weapons, and how she exposed bias not with rhetoric, but with the judge's own words and record. For young lawyers, especially women and minorities, her example was electrifying. It showed that knowledge, courage, and precision could dismantle even the most entrenched authority. Civil rights advocates built on the momentum. Attorneys in multiple states began filing motions citing patterns of judicial bias, armed with Crockett's method of cataloging reversals and ethical reprimands. Some succeeded in getting judges recused. Others forced appellate courts to address bias more openly. The idea that systemic bias in the judiciary could be confronted head-on was no longer unthinkable. It was happening. Politically, Crockett's stature soared. Within her party, she was no longer just a freshman congresswoman from Texas. She was a symbol of reform, a voice capable of bridging grassroots activism with institutional change. Invitations poured in, national interviews, keynote addresses, strategy sessions with reform groups. Her ability to turn legal precision into public resonance made her a formidable figure, not just in the courtroom, but on the national stage. For the judiciary itself, reforms began to take shape. Mandatory training on implicit bias in civil rights cases was adopted by the Judicial Conference. Reporting mechanisms for judicial misconduct were streamlined, making it easier for attorneys to document and challenge inappropriate behavior. The American Bar Association encouraged the creation of independent panels to review patterns of judicial decisions for signs of prejudice. None of these changes happened overnight, but all of them traced their spark back to the confrontation that had made accountability impossible to ignore. And for Judge Stones, history was merciless. His portrait, once destined for a place of honor among Texas legal elites, was quietly removed from courthouse walls. His name became shorthand for judicial arrogance and bias, invoked in op-eds and lectures as a warning of what happens when unchecked authority meets fearless scrutiny. He lived out his retirement far from the spotlight, a ghost of the power he once wielded. Yet the story was never really about him. It was about the principle Crockett defended, that no one, not even a federal judge, is above accountability. The pile of case files she carried into that courtroom became part of the permanent record, archived for future generations. They sit in the National Archives, a testament to the day one young congresswoman stood her ground and changed the trajectory of legal accountability in America. The legacy of that day was more than legal. It was cultural. It reminded the public that institutions could be challenged, that preparation could dismantle power, and that courage in the face of authority could inspire movements. It told every lawyer, every activist, every citizen that the system, while flawed, was not beyond repair, if people were willing to fight for it. And so, when history looks back at the showdown between Jasmine Crockett and Judge Andrew H. Stones, it won't just remember a viral clip, or a trembling gavel, or a pile of overturned rulings. It will remember the message it sent, that someone is always watching, someone is always documenting, and someone brave enough can always hold power to account. That was the true legacy, the reminder that justice, though often delayed, is never denied when courage and truth step into the courtroom. Political rhetoric. Crockett made a small notation, as if she were tallying something that would be useful later. Very well. Let's put causation aside and move to conduct. Your Honor, we have video evidence from 3 polling locations in which eligible voters are turned away contrary to posted procedures. The recordings are timestamped and corroborated by poll worker logs. She lifted a tablet. With the court's permission, we can play 60 seconds from location 2. Defense leapt like a sprinter out of the blocks. Objection. Prejudicial, lacks authentication, and is cumulative. Sustained, Stones said, before the last syllable of cumulative reached the carpet. He didn't look down at the screen. Move on, Congresswoman Crochet. The stir from the gallery spread, 1 part confusion, 2 parts recognition. People who'd watched courts long enough knew the difference between a gatekeeping objection and a moat. Crockett set the tablet down with deliberate care. Your Honor, this is direct evidence of a procedural violation occurring in real time. Authentication can be established with the poll workers and the device custodian. The jury— There is no jury, Stones said, the smirk returning like a reflex. And we are not a theater for amateur videos. Save your exhibits for Congress. The court prefers law. He didn't laugh yet. That came later. For now his voice carried a warmth that frostbites, the tone veteran judges use when they want to demonstrate that the rules are flexible, but only for them. The defense settled back, one of them glancing toward the ceiling, as if this were all going according to weather. Crockett inhaled once, slowly, as if tasting the room. The pen in her hand stopped moving. When she spoke again, her cadence changed. Shorter, colder, narrower, like a blade finding its edge. Then let's talk law. She opened a thin binder, not the thick folder waiting beneath it. We will rely on 3 pillars. Equal protection analysis under established precedent regarding discriminatory impact, statutory violations regarding poll access and resource allocation, and the state's own written procedures, which require uniform application across precincts. For now, I'm asking the court to admit Exhibits 5 through 9 for the limited purpose of showing notice to the defendants. Objection. Sustained. The word snapped like a rubber band against skin. Crockett didn't flinch. She stacked Exhibits 5 through 9 in a precise rectangle and pivoted. Then I'll begin with witnesses. We call Ms. Alma Ruiz, a poll judge with 15 years of service, to testify to the refusal to accept provisional ballots contrary to handbook guidance. Defense. Objection. Relevance until foundation. Stones. Sustained. Congresswoman, this is not your press conference. Lay your foundation. That did it. Somewhere in the second row, a court reporter briefly stopped typing, the universal sign of a moment worth remembering. Crockett lifted her gaze to the bench, her eyes level, her voice controlled enough to carry. Your Honor, I intend to lay the foundation. I also intend to protect this record in the event your rulings are reviewed. A few heads turned at the word reviewed. The defense counsel's pen paused mid-tap. Stones's smirk thinned. You may intend many things, Congresswoman Crockett. For now, you may intend to proceed within the rules of evidence. The mispronunciation again, casual and cutting, like misnaming a witness to make them smaller. Crockett let the silence sit for a beat, then said, Noted for the record. She closed the thin binder, set it aside, and finally placed her hand on the thicker folder beneath, its spine creased, tabs bristling with colored flags. The change was subtle but final, an audible click even without sound. The moment someone shifts from persuasion to accountability. Before we call our first witness, she said, there are preliminary procedural matters this court needs to address. Defense shook his head as if he'd been handed a menu he didn't order. Objection to this entire detour. Stones waved a lazy hand. On what basis? Relevance and timing. We're mid-opening. Crockett didn't look at the defense. She looked at the bench. The basis, she said, is judicial efficiency and the appearance of impartiality. If unresolved, these matters will infect every ruling to follow. A chuckle escaped the bench, soft, condescending, practiced. Not the infamous laugh yet, but its shadow. Stone settled deeper into his chair. The Congresswoman now lectures the court on impartiality. This should be enlightening. Crockett flipped open the thick folder. Tabs fanned like a deck about to be dealt. The court reporter resumed her keys, the gallery leaned forward, and the defense straightened an inch they couldn't afford to give away. Your Honor, Crockett said, and this time her tone left no oxygen for interruption. We'll start with the court's recent handling of civil rights cases in this district. The judge's hand tightened around the gavel. Someone's phone buzzed and was silenced. In one motion, Crockett slid the first document to the edge of her table like an opening gambit. The page gleamed under the fluorescence, stamped and indexed. She didn't lift the tablet again. She didn't need to. What was coming didn't require pixels or sympathy. It required dates, transcripts, reversals, and a record that could not be laughed out of existence. Clerk, Stone said, voice a half step too fast. Mark the... But the sound of paper rustling across lacquer drowned him out, a small thunder that carried to the back row and beyond the door. The courtroom had crossed a line it could not uncross, and when Crockett spoke next, she was no longer asking permission. She was starting the clock. The laughter didn't arrive like thunder. It slipped out like a leak in a dam, small at first, then widening until the whole reservoir of condescension came pouring through. Judge Andrew H. Stones tilted back as if enjoying a private performance only he could appreciate, a low chuckle swelling into a sound that flattened the oxygen in the room. It wasn't the laughter of a man amused. It was the laughter of a man assured. The gallery stiffened. Defense counsel let their shoulders relax. as if the verdict had already been written on the judge's face, and a reporter's pen stalled mid-scratch. The court microphone caught just enough for the back rows to hear the shape of the insult, even if they missed a syllable. Crockett didn't move. The thick folder lay open, its color-coded tabs like a skyline of dates and docket numbers. She didn't reach for it. She didn't roll her eyes. She didn't glare. She looked up, found the exact height of the bench, and waited for the last echo to die on the walnut panels. "Finished?" she asked. No tilt, no heat. Just the question, precise as a stopwatch. Stone's smirk reassembled itself, proud of having outlived the silence. "Congresswoman Crockett," he said, drawing out the name as if it were an unfamiliar object he intended to use anyway. "We prefer law to theatrics. If you've brought a lecture on judicial ethics from cable news, I suggest you submit it to the opinion page." The defense table smiled with their eyes. The gallery shifted. A court deputy folded his arms as though bracing for an inevitable admonition. Crockett placed 2 fingers on the first tab, blue, labeled with a neat hand, and slid a document 6 inches forward. "This is law," she said, "and it begins with your record." The defense chair on the left cleared his throat, winding up for the old standbys: timing, relevance, decorum. "Objection to counsel's personal attacks on the court." "Overruled," Stone said almost lazily, as if magnanimity cost him nothing. "Let her hang her arguments in public. The rope is hers." "Appreciated," Crockett said, and the court reporter's fingers fluttered with a tiny, involuntary pause at the word. "Because this rope is braided with transcripts, appellate rulings, and reversals. I'm moving for the court to take judicial notice of its own orders and of published opinions from the Fifth Circuit." That phrase, judicial notice, moved through the attorney's benches like a subtle tremor. You don't argue with a court about what's in its own files. You acknowledge, you contextualize, you pray. The context sounds like absolution. Defense counsel's pen did a nervous half-tap and then stopped altogether. Stone's tried for indulgence. "You may request what you wish, Congresswoman Crockett. The court is not in the business of entertaining fishing expeditions in the middle of openings." "This isn't a fishing expedition," Crockett replied, sliding the first page onto the center of the table without lifting her gaze. "It's a net, and everything in it has a case number." Stone's eyes flicked at the clerk. It was the smallest tell, barely there, but in a room primed for voltage, it read like a flare. The moment an incumbent advantage checks for exits. The clerk looked down, ready to mark something, anything, to slow the tempo by a beat. "Before we proceed," Crockett said, "I'm making a clear record. The court has sustained every defense objection thus far, including those directed at foundational steps we laid out in our pre-trial filings. The court has also repeatedly mispronounced counsel's name after correction and labeled video authentication as amateur theater without viewing it. Those facts bear on impartiality. They also bear on whether a reasonable observer would question the court's neutrality." The second defense chair found his voice. "Objection, argumentative and irrelevant, overruled," Stone said again, more sharply this time, irritated at being cast as generous twice. "The Congresswoman may vent. She will still have to prove a case when her monologue ends." "Good," Crockett said, finally lifting the first document, "because proving patents is what I do." She didn't rush. She read the caption aloud the way an operating room nurse reads a dosage. "Morrison versus Texas Secretary of State. Case no." She gave the number cleanly. Voting rights action dismissed at summary judgment. Ground stated, insufficient evidence of discriminatory impact. Counsel's assertions stray toward political theater. She let the last 2 words hang for a beat, then went on. "We'll get to that. For now, I'm asking the court to mark this for identification and to take judicial notice of its own order. Then we'll compare it to the Fifth Circuit's reversal." The gallery adjusted collectively, as if tugging its chair closer without scraping the floor. Stone's rested his palm on the armrest as if the bench had suddenly become a hill he might have to defend. He tried to reframe. "Congresswoman Crockett, even if I entertain your catalog, what exactly is the point? To relitigate closed matters for the benefit of the press?" Crockett held the document up, not for the cameras, there were none permitted, but for the record and for the rhythm. The point, Your Honor, is bias, not alleged in a vacuum, demonstrated across cases. A pattern in which civil rights plaintiffs are treated as agitators first and litigants second. A pattern identified by appellate courts using language this court labels political theater when it comes from us. Stone's jaw tightened so slightly that only those who watched Faces for Sport caught it. He didn't look down to the clerk this time. He looked at the clock above the doors, as if time could arbitrate tone. Defense tried to re-seize the wheel. If counsel wishes to move for recusal, the local rules provide a method. They do, Crockett said without turning. And I will. After this record is clear. The clerk's pen found the line for marking. The quiet scratch of ink was suddenly loud. Someone in the gallery coughed and swallowed it whole. Crockett placed the Morrison order flat on the table and set a second sheet beside it, flipping the tab. Green, appellate. Here, she said, tapping the first paragraph. The Fifth Circuit describes the dismissal as an abuse of discretion premised on a misreading of both the standard and the facts. Their words. Not mine. They remanded with instructions and, notable for present purposes, admonished the district court for comments that suggested, again their words, hostility towards civil rights counsel. No one sat back now. Defense had that particular stillness of people calculating angles under a surface that doesn't allow ripples. The gallery leaned forward because gravity had been changed by a sentence, and Stones, who had presided over 1,000 rooms exactly like this one, chose to look uninterested, the way a veteran chooses a seat at the end of the bar. Habit dressed up as confidence. Counsel, Stones said, stressing the word as if it tasted better than Congresswoman. One reversal does not a pattern make. Courts are reversed. It is the natural respiration of appellate review. Agreed, Crockett said. One reversal doesn't make a pattern. She turned the next tab, read, and slid the paper halfway out. 12 due. A ripple traveled the length of the wood rail. The court reporter didn't stop typing this time. She sped up, a stenographic sprint. Defense opened a binder that didn't hold the pages she was about to name. And the judge, despite himself, lowered his chin a millimeter, the human body's smallest concession to uncertainty. This was the hinge, not the laugh, not the smirk, not the easy overrules and sustains. The hinge was the moment the court realized it was no longer deciding how much argument to permit, but how much sunlight the record would bear. Crockett stood at the fulcrum, one hand on red, one hand on green, ready to pull the thread through both. She didn't spike the football. She didn't sermonize. She stacked. We will proceed chronologically, she said. Each item, case caption, district action, relevant comments from the bench, appellate result. The court will see the through line. The public will see it too. But I'm not making this for the public. I'm making it for the inevitable question a reviewing panel will ask. Was there evidence, in the record, that a reasonable litigant could doubt this court's impartiality? Counsel, Stones said, and there was a new word under the syllables now, grit. You are skating close to contempt. And you, Crockett replied, are skating close to grounds. Defense tried again, lighter, aiming for reason. Your Honor, if counsel intends to weaponize appellate dicta, we're entitled to address each item individually in briefing. You'll have your briefing, Crockett said, still not looking their way. What you won't have is time to pretend this is novel. The pattern predates this morning. The judge's gavel didn't fall. It hovered, literally and figuratively, an instrument held at the threshold between enough and too late. Crockett took the pause as consent and set the next document square to the first. Edges aligned as if geometry could shame bias into symmetry. In Morrison, she said, tapping the line again, the language is unmistakable. The Court of Appeals rejected the exact rationale this court used today to exclude our foundational exhibits. That's not coincidence. That's a template. The word template shivered through the defense team. Templates repeat. Templates are easy to spot. Templates get talked about at conferences and in drafting memos and, eventually, in opinions that carry the word systemic. Stones inhaled, weighing which tone would cost him less later. He chose dry. Proceed to your next exhibit, Congresswoman Crochet. Gladly, Crockett said. She placed her finger on the second tab, the One that led to the case that would punch a hole clean through the bench's posture, and the folder gave a soft creak like stage boards settling before the showstopper. "This next item," she said, "concerns Henderson." Year 2022, the gallery didn't exhale. It leaned forward. The court reporter's keys gathered speed. Defense counsel finally reached for water they didn't intend to drink. And the judge, who had laughed, didn't laugh now. Because everyone in that room knew what Henderson carried. Sanctions, headlines, and a Fifth Circuit opinion with adjectives that stick. And if Morrison drew a line, Henderson would turn it into a road. "Mark it," Crockett said to the clerk, and when the pen touched paper, the room understood that the rope wasn't hers at all. It was his. The courtroom had already shifted. The laughter was gone, replaced by a stiffness in the air that made even the creak of a wooden chair sound amplified. Crockett's blue-tabbed folder lay open on the table, the first domino in what the gallery suspected might become a chain reaction. Every legal reporter knew this was the pivot. What had started as a clash over one piece of evidence was now becoming a trial of the judge himself. Crockett didn't need theatrics. She had something sharper, transcripts. She lifted the first sheet with both hands and spoke evenly, as though she were calling roll. Morrison vs. Texas Secretary of State, 2023. Case number... She read it clearly into the record, her voice clipped and precise. Dismissed at summary judgment. Grounds cited by this court. Lack of sufficient evidence, assertions deemed, and I quote, political theater. She didn't dramatize those words. She simply let them hang in the air like a bad odor. A rustle ran through the gallery, reporters shifting notebooks, defense counsel adjusting ties. Everyone knew the phrase. Everyone also knew what had come next. Crockett turned to the second sheet, marked in green. The Fifth Circuit opinion reversing. Paragraph 1. This dismissal constitutes an abuse of discretion premised on a misapplication of the standard for summary judgment and a failure to credit undisputed factual evidence. She glanced up briefly at the bench. The appellate court did not mince words. Judge Stone's knuckles whitened as he gripped his gavel, but he didn't strike it. His face maintained the half-smile of a man trying not to show irritation. But Crockett pressed forward, her voice sharpening like a chisel finding the grain. The appellate panel further noted, again their words, not mine. Remarks from the district court suggesting hostility towards civil rights counsel raise additional concerns about impartiality. That sentence is part of the permanent record. This court's record. A low gasp spread through the gallery. The defense attorneys didn't object immediately. They knew objections would only underline the quote. Instead, one leaned back in his chair, staring at the ceiling tiles, while another scribbled furiously on a yellow legal pad. Stones leaned forward at last, voice clipped. Congresswoman, courts are reversed all the time. The idea that one reversal establishes, not one, Crockett interrupted, her voice cutting clean through his. Not isolated. Morrison is the beginning of a line. This isn't an academic reversal. It's a documented instance of bias identified by a federal appellate court. The same bias we are watching play out here today. The gallery shifted again, this time toward her, not the bench. For once, the energy of the room was not gravitationally bound to the judge's authority. It was tilting toward Crockett. She didn't break rhythm. Instead, she pulled out the actual transcript from Morrison, marked with a yellow tab. She held it up so the court reporter could see it clearly. Here are your words, Your Honor, from that very case. Direct quote, maybe stick to personal injury cases and leave constitutional law to people who understand it. The room cracked open. Gasps rolled through the gallery. Reporters scribbled like their pens were on fire, and even the defense team looked suddenly uneasy. The remark wasn't legal analysis, it was disdain. And hearing it read aloud in the judge's own courtroom gave it a weight heavier than any appellate ruling. Crockett placed the transcript flat on the table, her hand resting on it like evidence sealed in place. That's not an inference. That's not a plaintiff's allegation. That's you, on the record, belittling a civil rights attorney for daring to bring a voting rights claim. The Fifth Circuit noticed. The public noticed. And today this court notices again. Judge Stones tried to speak, but the words caught in his throat. For the first time all morning, his smirk faltered. He cleared his throat, grasping for authority. Congresswoman, you are out of order? Crockett's tone sliced through his attempted rebuke. No, Your Honor. I am firmly within order. Because this, she tapped the transcript, is order. This is precedent. This is the law. The gallery erupted in whispers. Reporters exchanged glances, already drafting headlines in their heads. Defense counsel looked as though they wanted to melt into the oak panels behind them. The court reporters' keys clattered with urgency, each stroke a nail securing the moment into the permanent record. Crockett leaned forward slightly, voice low but carrying like a drumbeat. You dismissed Morrison as frivolous. You mocked counsel. You were reversed. And today, you are sustaining every baseless objection from the defense while denying plaintiffs the chance to establish a foundation you know is proper. It's the same playbook, the same bias, the same pattern. The judge's face flushed red. He opened his mouth again, but Crockett didn't let him. She flipped another tab, a red one, and laid the next document beside the first. And if Morrison isn't enough for this court, let's talk about what happened in Henderson, just 1 year later. The gallery froze. Everyone knew the name. Henderson wasn't just another reversal, it was a public embarrassment. A decision so harshly criticized by the Fifth Circuit that legal commentators had debated whether Judge Stones would ever recover his credibility. The stage was set. Morrison had cracked the foundation. Henderson was about to bring down the house, and as Crockett's hand hovered over the document, ready to press it into the record, the silence in the courtroom carried its own verdict. The judge's grip on authority was slipping, and everyone present could feel it. The Morrison reversal had shifted the ground under Judge Stones's feet, but what came next would hit like a landslide. Crockett didn't even pause for the murmurs to die down. She reached for the red-tabbed sheet, slid it across the polished wood, and spoke with the precision of someone laying charges on a detonator. Henderson versus Texas Board of Elections. 2022, case number... She read it clearly, each digit deliberate. Filed as a voting rights action alleging discriminatory ballot access procedures. This court not only dismissed the plaintiff's claims, but went a step further, imposing sanctions on the attorneys for bringing what you called a frivolous lawsuit designed to generate media attention. The gallery stiffened. Even some members of the defense team exchanged wary glances. Everyone remembered Henderson. It hadn't just been a dismissal. It had been a humiliation. Sanctions meant to punish lawyers for daring to bring the case in the first place. Crockett turned to the appellate ruling, green tab again. The Fifth Circuit reversed. The sanctions were vacated in their entirety, and the appellate opinion described this court's behavior, and I quote, as inappropriate and potentially biased. Those are the words of 3 federal appellate judges. Not activists, not politicians, judges. She let the silence ride for a moment. The courtroom was so still that the faint hum of the fluorescent lights above seemed louder. Your Honor, she continued, you never apologized to those attorneys. You never retracted the sanctions. You attempted to stain their reputations and their careers for bringing a case that the appellate court confirmed had legal merit. That stain lingers to this day. Defense counsel finally rose too sharply, knocking a pen off the table. Objection, Your Honor. Counsel is making inflammatory statements not relevant to this proceeding. Crockett didn't even turn her head. This is entirely relevant. It demonstrates a repeated, documented hostility toward civil rights litigation. Henderson wasn't an isolated case. It was part of a pattern. And if this court wants to talk about relevance, then let's talk about the relevance of appellate courts explicitly flagging bias in your rulings. Judge Stones's gavel slammed down, the crack echoing like a gunshot. Enough, this is not your stage, Congresswoman. You are not here to put this court on trial. Crockett didn't flinch. She leaned forward, both palms flat on the table, her voice measured but fierce. With respect, Your Honor, this court is on trial. Every ruling you've made today has underscored what the record already shows, a bias so entrenched that it infects even the simplest evidentiary decisions. Henderson was not about me. It was about whether lawyers have the right to bring civil rights claims without being mocked and sanctioned. The appellate court said they do. You said they didn't, and you lost. Gasps rippled through the gallery. Reporters' pens flew across notepads. A few even lifted their phones, hands hovering, desperate to capture every syllable, even though official rules barred recording. Crockett slid another page forward, this one highlighted. Here is the exact line from the Fifth Circuit's opinion in Henderson. The district court's decision to sanction plaintiff's counsel reflects not impartial adjudication, but an appearance of hostility toward an entire class of claims. Such conduct undermines public confidence in the judiciary. She paused, letting the words hang like a bell tolling over the courtroom. Then she added, "That's not my assessment. That's the federal appellate court's assessment of you." The judge's face went crimson. His hand trembled slightly on the gavel. But Crockett wasn't finished. She reached back into her folder, pulling out copies of the appellate opinion, and handed them to the clerk. "Mark these for the record, because Henderson proves this isn't about an occasional mistake. It's about a documented hostility towards civil rights litigation." The defense tried again, desperation creeping into their tone. "Your Honor, if this court allows this sideshow, we'll be here all day." "Counsel is hijacking these proceedings." Crockett turned toward them, her eyes blazing. What hijacked these proceedings was a judge laughing at constitutional violations. What hijacked these proceedings was a history of bias so undeniable that appellate courts had to step in again and again. If shining light on that record feels like hijacking, perhaps it's because the truth isn't flattering. The gallery erupted in whispers, louder this time, almost impossible to contain. The bailiff barked for order, but order wasn't coming. Not now. Crockett placed Morrison and Henderson side by side on the table, the two reversals forming the spine of her argument. She looked back up at Stones, her voice calm again, almost surgical. "Your Honor, 2 cases could be coincidence. 12 is not. Henderson was your warning shot. You ignored it. Now we are here again, and I assure you, Henderson won't be the last example." Judge Stones leaned back, his smirk gone, his face pale beneath the flush of anger. He looked less like a man in control of his courtroom and more like a man realizing control had slipped through his fingers, and Crockett, without missing a beat, reached for the next tabbed case file. Williams v. Texas Department of Public Safety 2021. Shall we continue? The gallery leaned forward as one. They knew they were watching something historic, something that would be replayed in law schools and documentaries for decades. Stones had underestimated her. Now the avalanche was rolling, and Henderson had only been the second stone to fall. The real landslide was still coming. The Henderson reversal had landed like a thunderclap, but Crockett wasn't interested in thunder. She wanted an avalanche. She wanted weight, momentum, inevitability. 1 reversal could be brushed aside, 2 could be rationalized as aberrations. But a dozen? A dozen was a doctrine. She flipped to a new tab, orange this time, and slid another case across the table with surgical calm. Williams v. Texas Department of Public Safety. 2021. Your Honor dismissed this civil rights complaint with prejudice, calling the plaintiff's evidence, quote, political theater. The Fifth Circuit reversed again. She didn't raise her voice. She didn't need to. The pattern was doing the heavy lifting. Next tab, yellow. Jackson v. Harris County Elections 2020. Plaintiffs alleged unequal ballot access. You told their attorney, and I quote, stop wasting the court's time with conspiracy theories. The appellate court reversed. Again, a gasp ran through the gallery. The phrasing wasn't neutral judicial language, it was ridicule. And now, hearing it in the Congresswoman's voice, it sounded like nails in a coffin. Crockett kept the rhythm tight, deliberate, each new case stacking like bricks in a wall closing in on stones. She flipped another page, red tab. Thompson v. Texas Legislature 2019. Plaintiffs challenged redistricting maps. Your Honor dismissed the case and suggested on the record that the plaintiffs find a hobby other than suing the state. The appellate court reversed, again. Not only that, they issued a formal reprimand from the Judicial Conduct Board. Reporters' caucusizio pens were flying so fast they seemed ready to tear through their notebooks. The gallery was leaning forward, caught between disbelief and awe. Defense counsel had gone silent, whispering among themselves but refusing to object, knowing each objection would only spotlight the words again. And Crockett wasn't slowing down. She pulled another document, green tab, and laid it on top of the others. Patel v. Texas Department of Education, 2018, voting access case. Dismissed after you characterized the plaintiffs as activists looking for a courtroom soapbox. Reversed. Again. Then another. Blue tab. Johnson v. Dallas County, 2019. Plaintiffs allege systematic ballot rejections in minority neighborhoods. You ruled their evidence insufficient to warrant serious consideration. The Fifth Circuit disagreed, reversed. The pile of documents on Crockett's table was growing taller, thicker, undeniable. Each page marked with appellate reversals, each one carrying the weight of judicial rebuke. "Do you see the pattern, Your Honor?" she asked, her voice steady, her eyes locked on the bench. Because the appellate courts certainly did. Time after time, civil rights plaintiffs enter this courtroom seeking equal protection. Time after time, you dismiss their claims with ridicule, with sanctions, with disdain. And time after time, appellate courts have reversed you, rebuked you, reprimanded you. She paused, letting the silence choke the room. The gallery didn't dare breathe. Even the bailiff's face betrayed a flicker of recognition. This wasn't just advocacy, this was exposure. Crockett continued, her tone sharpened into steel. 12 cases in 5 years. 12 reversals. 12 instances of appellate courts identifying hostility, bias, or misconduct. This isn't coincidence. This is a template. And that template is being followed again, right here, right now, in this case. Judge Stone's face had gone pale, drained of its usual color. He clutched the gavel like a lifeline, his jaw tight, but he didn't strike it. He knew striking it would only sound weak, like a man trying to drown out the truth with noise. Crockett spread her hand across the documents like a dealer laying down a winning hand of cards. Williams, Jackson, Thompson, Patel, Johnson, and more. All reversed. All marked with your words, your dismissals, your ridicule. This courtroom is not impartial ground. It is quicksand for civil rights plaintiffs. And today, the record is making that clear. The gallery was no longer whispering. They were buzzing like a crowd watching history unfold. Reporters scribbled furiously, already envisioning headlines. Congresswoman exposes judge's pattern of bias. Defense counsel finally rose again, their voices strained. Your Honor, this is a circus. Opposing counsel is grandstanding, turning a courtroom into a stage for political theater. Crockett snapped her gaze toward them, her voice sharp enough to cut glass. Political theater? That's what Judge Stone's called Morrison. That's what he called Williams. That's what he called Thompson. And every time he said it, appellate courts reversed him. If exposing bias and quoting appellate rulings feels like theater to you, perhaps it's because the truth plays louder than your objections. The gallery broke into hushed applause before the bailiff barked for order. Stones raised his gavel halfway but didn't bring it down. His authority was no longer absolute. It was being held hostage by the record in front of him. Crockett leaned forward, her voice low but cutting through the room like a blade. Your Honor, if Henderson was the warning and Morrison was the crack, then this stack is the avalanche. 12 cases. 12 reversals. 12 times civil rights plaintiffs had to climb out of the ditch your rulings dug for them. And I assure you, we're not finished yet. She let the silence linger, her hand resting on the thick folder still half full. Because the most damning case of all hasn't even been mentioned. The gallery froze, eyes darting, ears straining. Stones gripped his gavel harder, his hands trembling now, his once confident smirk long gone. Crockett tapped the final sealed document in the folder. Davis v. Texas Attorney General 2021, shall we? The air snapped tight. Everyone in that courtroom knew the name. Davis wasn't just a reversal. Davis carried a quote that had haunted Stones for years, a quote that could end a career, and Crockett was about to read it aloud. The air inside the courtroom was already electrified from the avalanche of cases, but when Jasmine Crockett slid the final tabbed folder across the table, the temperature seemed to plummet. Everyone knew the name, Davis v. Texas Attorney General. It was the case whispered about in law school hallways, dissected in legal blogs, and gossiped about in bar associations across the state. It was the one that had almost ended Judge Stone's career before, and now Crockett was about to resurrect it in his own courtroom. She placed the file flat, her hand resting lightly on the cover. Your Honor, let's talk about Davis versus Texas Attorney General 2021. The defense attorneys stiffened. Even they weren't smiling anymore. The gallery leaned forward as one body, hungry to hear the words that had lingered like a ghost in judicial circles. In that case, Crockett continued. her voice calm but razor-sharp. Civil rights organizations brought a straightforward voting rights lawsuit. They presented direct testimony, documented evidence, expert analysis, yet this court dismissed it outright. She flipped open the folder, revealing stamped transcripts. And during those proceedings, you made comments that were recorded and transcribed. Comments that go far beyond dismissive. Comments that cut to the heart of bias. Judge Stones shifted in his chair. His gavel hand trembled slightly, the wood tapping softly against the block like a nervous tick. "Congresswoman, I will not allow—" But Crockett didn't stop. She read directly from the transcript, her voice steady, loud enough to carry to the farthest row of the gallery. "You told the plaintiff's attorneys, and I quote, 'These people need to stop complaining about every little rule and learn to follow the law like everyone else.'" The courtroom erupted. Gasps ricocheted against the walls. Reporters dropped pens, scrambling to underline the phrase. The gallery buzzed with shock, disbelief, outrage. Even the defense lawyers looked rattled, their eyes darting nervously toward their client and then toward the press benches. "These people." Crockett repeated the words slowly, deliberately, each syllable cutting like a scalpel. "Your Honor, everyone in this room understands exactly what that phrase means. You didn't say the plaintiffs. You didn't say the organizations. You said these people. And in the context of a voting rights case brought by minority voters and civil rights groups, the meaning is unmistakable." Stones slammed his gavel down so hard it echoed like a gunshot. "Enough! That comment is being taken out of context. The investigation into that case was inconclusive." "Inconclusive," Crockett cut in, her voice rising over his. "Only because the process for investigating federal judges is slow and stacked in your favor." "But that doesn't erase the words. It doesn't erase the record. It doesn't erase the fact that an appellate court reversed you in Davis and referred your conduct to the Judicial Conduct and Disability Committee for investigation. That referral happened. It's public record." The judge's face drained of color. His smirk was gone, replaced with something approaching panic. He glanced at the clerk as though looking for an escape route, but there was none. Crockett pulled out the appellate opinion and laid it beside the transcript. "Here is what the appeals court said after reviewing Davis. I quote, 'The district court's comments risk undermining the appearance of impartiality and suggest a prejudgment of claims brought by minority plaintiffs. Such remarks are inconsistent with the obligations of judicial office.'" The gallery broke into hushed chaos, reporters whispering into phones, court staff exchanging stunned glances, even the bailiff shifting uneasily in his stance. Crockett's voice dropped lower now, calm but deadly precise. "This wasn't me saying it. This wasn't the plaintiffs saying it. This was the appellate court saying it. They didn't just reverse you, they referred you. And that referral is still on record. It may have gone dormant, but referrals don't die. They wait, and with new evidence of a pattern, with Morrison, Henderson, Williams, Jackson, Thompson, Patel, Johnson, all of them. Every single one, the referral can and will be reopened." She spread the documents across the table, forming a mosaic of reversals, reprimands, and transcripts. This is not coincidence. This is not politics. This is not theater. This is bias. Documented, repeated, undeniable bias. A bias that disqualifies you from presiding over this case or any civil rights case. The gallery was no longer whispering. They were staring in awe, many with mouths open, as though they were witnessing the unthinkable. A freshman congresswoman dismantling a 20-year veteran federal judge in real time. Stones leaned forward, his voice cracking slightly. "Congresswoman, you are dangerously close to contempt of court." Crockett met his gaze without flinching. "With respect, Your Honor, the only contempt in this courtroom is the contempt you have shown for the Constitution, for civil rights plaintiffs, and for the very idea of impartial justice." Reporters bolted for the exits, phones already buzzing with breaking news alerts. The phrase, "these people," was about to become the most viral legal quote of the year. Crockett's voice cut through the chaos with clarity and finality. "For these reasons, Your Honor, I move that this court recuse itself from this case on the grounds of demonstrated bias and prejudice." I further move that this case be reassigned to a judge who can evaluate the evidence fairly and impartially." The room exploded. Shouts, gasps, frantic scribbling, the sound of dozens of footsteps rushing toward the doors. Even the defense team sat frozen, too stunned to mount an objection. And at the center of it all, Judge Stones sat pale and shaking, staring at the woman who had just ended his career with nothing more than transcripts, appellate rulings, and the truth. For a moment, after Crockett's motion for recusal, the room was suspended in silence. The only sound was the faint whir of the ceiling fans and the rapid-fire keystrokes of the court reporter, immortalizing every word. Then Judge Andrew H. Stones lowered his gaze, his lips parted as if to speak, but no words came. His hand trembled against the gavel, the wooden handle slick from his grip. Finally, he muttered, barely above a whisper, "Court is in recess. We'll resume tomorrow." He tapped the gavel once, weakly. The sound didn't echo with authority. It thudded like a closing door. The courtroom detonated. Reporters shot from their seats like sprinters off the blocks, racing for the exit. Defense attorneys huddled, whispering urgently, eyes wide with the sudden realization that their judge-shaped shield had crumbled. Court staff exchanged glances, their whispers buzzing like a swarm of bees. Even the gallery, ordinary citizens, students, and local activists, knew they had just witnessed something seismic. But the real explosion wasn't inside the courtroom. It was outside. Within minutes, the courthouse steps became a frenzy. Phones were raised high, reporters live-streamed breathlessly into cameras, and hashtags erupted across social media before Judge Stones even left the bench. "Jasmine destroys. Judge trended within the hour." Clips from the courtroom's public gallery, grainy, shaky, but undeniable, spread like wildfire. The moment Crockett read aloud the "These People" line played on loop across TikTok, Twitter, and Instagram, often paired with dramatic music or flashing captions. Some users slowed it down for effect. Others juxtaposed it with archival footage of Stones dismissing previous cases. On YouTube, compilations titled "Jasmine Crockett versus Judge Stones: The Complete Takedown" began racking up hundreds of thousands of views. One channel overlaid her words with courtroom drama soundtracks, while another analyzed every legal point she made, timestamp by timestamp. The media caught fire, too. CNN legal analyst Jeffrey Toobin tweeted, "I've covered trials for 30 years. What Jasmine Crockett just did in Judge Stones' courtroom wasn't advocacy. It was accountability. A masterclass." Harvard law professor Sarah Martinez chimed in. "Crockett didn't just argue a case. She exposed systemic bias. This will be studied in law schools for years." Even conservative commentator Tom Bradley weighed in, tweeting, "This wasn't law. It was a political ambush disguised as litigation." Crockett turned a courtroom into a campaign rally, but the backlash didn't matter. The evidence Crockett presented, the transcripts, the appellate reversals, the judicial reprimands, spoke for themselves. Legal reporters across Texas scrambled through their archives, pulling old rulings, connecting dots, corroborating everything she'd laid out. By evening, the Dallas Morning News had published a full timeline of Stones' most controversial decisions, neatly matching Crockett's avalanche of cases. The Texas Tribune revealed that they had been investigating Stones for months, but couldn't get attorneys to speak on the record. Until now. Crockett had broken the silence wide open. Civil rights groups wasted no time. The ACLU released a statement within hours. Congresswoman Crockett's motion for recusal is not only justified, but necessary. Judge Stones has demonstrated a pattern of hostility toward civil rights, litigation that undermines confidence in the judiciary. Even the conservative Federalist Society, normally quick to defend, embattled. Judges remained conspicuously silent. By the next morning, the chaos inside the courtroom seemed almost tame compared to what was unfolding outside. Crowds gathered at the courthouse, holding signs that read, "No judge above the law," and "We stand with Jasmine." Local news crews jostled for camera angles, while national outlets flew in legal correspondence to cover what was quickly being dubbed the Crockett confrontation. And then, the kicker, Judge Stones didn't show up. Instead, his clerk appeared promptly at 9 a.m., her voice trembling as she read from a short statement. "Due to health concerns, Judge Stones has requested an indefinite medical leave. This case will be reassigned to Judge Maria Rodriguez. The phrase health concerns fooled no one. Within minutes, legal analysts on cable news were calling it what it was, a face-saving retreat for a judge whose career had just imploded in real time. Twitter lit up again. One viral post read, "Translation, he's gone. Crockett just retired a federal judge with nothing but receipts." The New York Times ran the headline. Federal judge steps down amid allegations of bias. Courtroom showdown with Congresswoman Crockett sparks national debate. For Crockett, the fallout was overwhelming. Her congressional office phones rang nonstop. Civil rights attorneys from across the country calling to share their own stories of judicial bias. Law professors emailed invitations to speak. Legal advocacy groups begged her to headline their conferences. But Crockett didn't hold a press conference, didn't crow about her victory. When reporters cornered her on the courthouse steps, she spoke calmly, almost understated. "This isn't about me. It's about making sure every American, no matter their background, gets equal treatment under the law." Yesterday wasn't a takedown. It was accountability, and it's long overdue. Those words played on every major network that night, alongside split screens of Stone's gavel trembling in his hand and Crockett's steady voice reading from transcripts, the confrontation that had started with a smirk. And a laugh had now become a national reckoning. And it was only the beginning.